Good afternoon, everyone. My name is Chanyne Cunningham. I am a attorney with Legal Aid in Collier County, Legal Aid Service of Collier County. Today, it's January 20th, 2021, and we're going to talk today about small claims court. And basically, I'm going to go through what the process is and what the steps are that are involved in small claims. So before I start, I'm going to give you a disclaimer that I am a lawyer with a legal aid service of Collier County, and I'm providing you with general information. Um, and as such, it's not legal advice. It's very general in nature and informational purposes. I am a lawyer. I am not necessarily your lawyer, even if I were to answer questions or something for you today. Unless I sign some type of retainer agreement with you, you're not my client and we have no client relationship. So with that out of the way, I'm going to go forward. And so what is small claims court? Well, small claims court is a way for people to handle smaller disputes and smaller issues. It's by smaller disputes, what we would be talking about is things in the neighborhood of $8,000 or less. Any dispute involving that amount of money of $8,000 or less is generally filed as a small claims case, small claims lawsuit. $8,000 is a fairly new figure. It went into effect of January 1st of 2020. So it's been around for about a year now. It used to be 5,000. A lot of people are more familiar probably with 5,000, but typically small claims court cases do not have a jury. Your case is heard by a judge. As you can see up at the top of the screen is a picture of Judge Judy. The kind of things that she hears typically would be small claims cases or small claims court cases. But I wouldn't go on the people's court necessarily for how it actually runs or how judges act. These cases can cover a wide range of topics. Generally, typically, they do not include family law cases, anything involving domestic relationships, things like that, and mortgage foreclosure disputes or mortgage issues or foreclosure disputes cannot be heard in small claims. A majority of the cases that I see when I'm in small claims court are related to unpaid debts and or unpaid loans or credit cards, things of that nature. There's also medical bills and things like that that people get sued on, but you do see some neighborhood disputes. Sometimes like a tree fell on somebody else's property and broke their fence or something like that, and they want to be paid for it. Things, smaller issues, but things that obviously they couldn't settle between themselves. So who can file a small claims case? Well, just about anyone, to be honest with you. There's only a few requirements. I mean, you have to be at least 18 years of age, or if there's a minor who has a minor, someone being under 18, if they have a claim, a parent or guardian can file a claim on their behalf. And the only other thing you have to have really is you have to have a claim that's less than that does not exceed $8,000. So those are basically it. Unlike other court divisions, such as county court, which is county civil court, which is a step higher. If you're over 8,000, you would go up to county court, or circuit court, which is a much bigger much bigger amount of money in dispute. Corporations generally in the larger courts cannot represent themselves. They must have an attorney, and there's rules in the Florida, small claims civil rules and the Florida civil rules of procedure that put this in writing and make it law or make it the process. In small claims, however, a corporation doesn't have to have an attorney. It can be represented by an officer or an employee who is authorized by the corporation in writing to represent the corporation. So if you were to sue, you know, Billy Bob's lawnmowers because of something, Billy Bob doesn't have to have an attorney. Billy Bob can do it, or he can, have somebody else from the company, Jim, go and be his representative. The only time that they cannot represent, that's during trial proceedings. So anything up until you have a judgment or a dismissal or something, they can. If a corporation is trying to enforce collections actions, like they get a judgment and they want to take money, then they must have an attorney. Okay. So how do you file it? How do you file a small claims court suit? So the process starts with, you have to submit 2 documents minimum to the clerk of court. One is called the statement of a claim. In other courts, it's normally called the complaint. And 2, you have to submit a summons, and you have to submit a summons for each person that you are making a claim against. You must also pay a required filing fee, and a fee that also is for issuance of the summons. The fee is basically dependent on how much the amount in dispute is. So if your claim is less than $100, you're going to spend $55 minimum just to file the complaint or file the small claims action. Sometimes it may not be worth it. But it goes all the way up to like $300 if you're somewhere between 2,500 and 8,000. So there's a little bit of, a financial investment to file these cases. And in order to get a summons issued, the clerk requires a $10 fee per summons. So every person that you're suing has to be summoned, and that would be $10 a piece. So what is the statement of the claim? Well, a statement of a claim is a document that you file, but what it does is it lays out who the parties are in the lawsuit or to the suit, and it describes what you are trying to be awarded or what you're claiming. So the person filing the lawsuit is known as the plaintiff. The person who you're suing, who's being sued, is called the defendant. And the statement of the claim basically is, what went wrong and what are you asking the court to award you because of whatever went wrong. There's a form available from the Collier County Clerk of Court's website that gives you that'll give you some ideas as to how to format this thing. And there's a web address here. I'm going to show you the form that the clerk has. It's a fill in the blank kind of form, or you could retype it yourself, however you wanted to do that. Some of the forms are in a PDF format that allows you to edit the blanks, so you could type it in and then print it, which is generally a nice, makes it neat and easy to read. If you do fill out these forms, the clerk requires you to fill them out in black ink. Blue is sometimes when they go to scan things and everything's now digital, blue doesn't show up as well, apparently. So here is the form that the clerk has. And at the top, it's called the caption. It just basically says that you're in county court in Collier County, you're in the small claims division. And there's a space here where it says plaintiff. So you would write in who is filing the lawsuit versus, and then there's a space here for whatever the name of the defendant. There's a couple spaces because there can be multiple defendants, or some people might have a long name. The case number generally is left blank because you don't know what it is until you give it to the clerk. Down here, there's a place for the defendant's address and phone number. This is so that if need be, we know where the defendant can be located or contacted. Also, so this is what's called the caption, basically, and this is the title of the document. It's a statement of claim. So It goes on to say plaintiff, and then there's a blank. So whoever the plaintiff is, you throw their name in there. Sues defendant. There's a blank for whoever the defendant, write the name in. And it says, this is an action for damages that does not exceed $8,000, exclusive of costs, interest, and attorney's fees. There is now due and owing and unpaid from the defendant to plaintiff. And then there's a blank for a dollar amount. There's a dollar sign there, and that's where you would list what amount of money, up to 8,000 that you're looking to recover. And then there's with interest, and if it's applicable, you circle that for the following reasons. And this is the area where you would elaborate as to what went wrong and why you believe the money is owed to you. Okay. At the bottom, there's what's called a prayer for relief. It says, wherefore the plaintiff demands judgment against the defendant for damages and costs. Then there's a place for the plaintiff's signature. The plaintiff needs to provide his information about address and phone number and things like that. Typically, it helps if you also include your email address there. Court documents get delivered via email. They'll deliver them via mail, postal mail too. However, it's a lot quicker if you get email, because it'll go out the same day that any document is generated by the clerk of the court. As soon as it hits, the court file, it'll go to you also. So this is just a basic. If you have a problem that needs more room than this little blank space here, you can attach a blank piece of paper or another piece of paper and just write continued and on page 1 or on page 2 on page, So if when you go to file a small claims suit, if you're relying on a document that say is some type of contract or some type of agreement that you've signed with the person, you need to attach a copy of that document to the back or to the end of the complaint when you go, or your statement of claim, so that the court and the defendant knows what you have to show the basis for your complaint of your claim. So that's where that's why there's that requirement there. So that is that. Now I can't get out of. Oh, there we go. I couldn't get the laser pointer off. So that's the basic form that you need. There's also, like I said, you need to file a statement of claim, but you also need to file a summons. So what is a summons? A summons is a document issued by the clerk of court, basically that notifies a person that they have been sued and what the other party, that they're being sued. It must indicate who the plaintiff is, who the defendant is, the address where the defendant can be served, the summons. Someone has to actually, make sure the defendant gets a copy of this statement of claim. And this information must be provided by the plaintiff when submitting the summons. No one is going to provide this information. The person filing the lawsuit has to provide that information. Once submitted, the clerk of court will assign a date and time for an appearance at what's called a pretrial conference and issue the summons. And when you go to file, also the summons contains basic information as to the court process for those unfamiliar. It's not legal advice necessarily. It provides you some very basic limited things that the clerk believes you should know. And it discusses some legal issues, such as something called venue. Does the person have the right to even sue you in Collier County? Or was there a suit that should have been filed in another county, and things like that. So here is the summons that the clerk has provided. It's a form also. And as you can see, maybe not, it's pretty small, but when you fill this out, there's a place up at the top here where the laser pointer is for the plaintiff you to write the name of the plaintiff, for you to write the name of the defendant, There's an address for the defendant to be served at. Again, they want to make, you have to provide the address. There's a case number, which the clerk will probably provide, and the judge's name the clerk will provide. Otherwise, this is basically the clerk, other than this top part where the caption, which was what we called it before, the clerk is going to fill in. So what does the clerk fill in? Well, you're like I said, she's going to give you a date for a pretrial conference, and she's going to write it in right here on blank at blank time for you're required to appear for a pretrial conference. And there's like I said, there's some other information, like important, read carefully. If you need an interpreter, you have to bring your own interpreter. And the case is not going to be tried at the time of the pretrial conference. So you're not going to have a trial. You're not going to see the judge. So don't bring anybody who you need as a witness to this. And you have to appear in person, or if you have an attorney, the attorney can appear on your behalf. So if you're the defendant must appear. And if you fail to appear, it's going to cause serious problems for you. If you need to reschedule something, if you can't make it, and I'm talking about can't make it, not it's inconvenient, you can only be rescheduled by approval of the court. So you would have to contact the clerk and try to get it continued. On the second page, that over here, it talks about a motion for continuance, where you need time. It tells you what you can do to get more time. Over here, it begins to talk to you about venue a little bit. It's like where you can be sued. And if you're the defendant, if you think it's the wrong place, you have the right to ask the court to move this to the right court. Say I sued somebody for in small claims court, and they are in I went to Tampa, and I got something fixed. I got some jewelry repaired, and it didn't take, and I needed to go. And I think, I paid them good money. They didn't do good work. The jeweler, I try to work it out. He refuses to help, and he's caused a problem now. So I come down to Collier County and I sue him. Well, everything that transacted in this whole thing didn't happen in Collier County. And the defendant, who is the jeweler, he doesn't live in Collier County. He doesn't do business here. So Collier County probably is not the right place for that lawsuit to be filed. So if the jeweler wanted, he could ask the court to say, hey, Your Honor, I live up here. All the work was up here. Everything happened up here. We need to move this. This case needs to be moved to Tampa. And there are procedures for that to happen. So that's just a little bit about venue. Also, there's a section here about telephonic appearances. It's both for parties and witnesses. You need to read this because it's very important that you understand how the judges are working with this. And there's some other general information here. The clerk in the court is not a collection agent. They don't guarantee that if you win, you're going to get any money, and they're not there to be the agent to get you your money. But there's some very good information. I would suggest that if you ever do this, if you either are a defendant or if you are filling out the summons, that you read this, because it's got a lot of good information that you should know prior to going through with a small claim suit. So that's the summons form. So I told you the clerk issues the summons, and that the summons has to get to the defendant somehow. So the process of getting the summons to the defendant is called service. So how do you do that? Well, there are a couple ways to do that. Okay, the first way is if you request from the clerk they will mail for a fee the summons and the paperwork required, by the to be delivered to the defendant. They will mail it to them via certified mail, return receipt requested, meaning they have a way to track that the documents have actually reached the defendant and he signed for them and he has them. Okay. The second way is you can hire a private person called a process server, civil process server. He basically, it's a person who has whose job it is to go out and find people, generally because you provided them an address, and then they go out there and they basically hand the person the paperwork and tell them that, hey, this is your court date, blah blah blah, and you've been served. So the other way to do that is to hire the sheriff's office. Now, the sheriff's office has a division called the civil process division. That's pretty much what they do, is they serve court-related papers. So this would be a court-related paper, and the sheriff's office serves that. Now, I think by far the cheapest method is the mailing of the certificate. Personal or private, process servers, they set their own rates. I think they're fairly competitive with the sheriff's office. The sheriff's offices in Florida are basically required by statute to serve at a preset price, which is currently $40. So that's another fee that you will incur, is a service fee. Like I said, if it's the mailing, it's a little bit cheaper. The service by the private process server and the sheriff probably somewhere in the same, in the same area. So, whichever one you choose. I will say that, service has to be complete prior to the date by the pretrial conference, because if you show up and there's no, obviously if the pretrial conference comes around, you're required to be there too, as the party, plaintiff suing the other party. You'll be there at the pretrial, because everybody must go, and the court will be the clerk will look in the file. They'll either see that you have served or you have not served. If you have not served, if there's no proof that the defendant has been served, your case is going to be continued to a future date, and it's going to, obviously have to get service done by that date. I will say, just a note about service by mail. Although it's less costly, it's probably not the best option. The problem is the defendant can refuse to accept certified mail. So, if the postman goes there and says, I have the certified letter to you, and the guy says, no, I don't want to take it, there's no service, because the defendant doesn't have that information in his possession. What you get when you do personal service by a private process server is they're going to hand that document to the individual or to someone in their household that's of age, but they're going to fill out an affidavit or a document just saying, I handed it to this person and on this date at this time, and that's going to be in the file, and that's going to show, hey, the person got service, and I can go ahead with the pretrial. And the same with the sheriff. The sheriff is going to fill out the affidavit as well. So, it's just a matter of, preference or price. I don't know. Like I said, I think both are roughly the same price. But, service by mail can be problematic. Completing service is the responsibility of the person bringing the lawsuit, who is the plaintiff. No one is going to help you. They're not going to say, hey, we'll mail this for you, or, they're going to hand, the clerk will issue a summons and they will give it to you and say, what do you want to do with it? And you can take it, or you can tell them I want the sheriff to serve it. And if you do that, they may keep it if you give them the payment right then for the sheriff. and they'll put it in the sheriff's. The sheriffs have a bin, have like a mailbox there, and they pick up that stuff. So at the clerk's office, but then the sheriff will take it and try to find them. But no one's going to do it for you. It's going to be your responsibility to go and do the service, or to make sure service is complete. So now that the claim is filed, what are we going to do? Well, as we said, the clerk is setting this thing called the pretrial conference, and it's what's on the subpoena, or on the summons. I'm sorry, that should actually say summons. The next step is obviously pretrial conference. All parties must appear at the pretrial conference. Everyone has to show up. Like I said, it's the defendant has to show up. If the plaintiff is represented by an attorney, the attorney can represent. However, whoever shows up has to have the authority to settle the case that day if terms can be agreed to. The consequences for not showing up for the plaintiff, if you don't show up and nobody shows up for you, like your attorney, your case is going to get dismissed. The judge is going to throw your case out because you failed to show up. If the defendant doesn't show up, the person being sued, the court's going to issue what's called a default judgment against them, and they lose. And you're basically, the plaintiff is going to basically get what they asked for, because you didn't show up and you didn't participate in the trial, or in the pretrial conference. So what is the pretrial conference, and what happens at the pretrial conference? There's a whole bunch of people that show up. In the past, before COVID, they would have the summons would tell you to appear at courtroom 2A or 1A, and you would go down, you'd go through the metal detectors, and there would be a huge, it's a fairly large courtroom with a bunch of attorneys at the front and a lot of people sitting in the pews, in the gallery, where in the seats to watch, where you would normally watch or wait for something. And then there's the clerk, and basically it looks like a cattle call. Like there's just there's a lot of people there, but they're all there for this pretrial conference. And what it is it's a meeting basically between the plaintiff and the defendant, and usually, almost always, a mediator. The court provides a mediator. And the goal is to get you guys together, the plaintiff and defendant, get you to get together with a mediator and see if there's any way that you can come to an agreement to settle this case without needing to go forward and see a judge. Now, the mediator is there to try to facilitate a settlement. The mediator is a neutral party. He probably doesn't know either of you, and if he does know one of you, he's supposed to not take your case. There's generally several mediators, a number of mediators at every pretrial conference. And like I said, it's not just you, there's a whole bunch of other people. So generally there's plenty of mediators to, if you know one or something, that would be okay. And then many of these cases, like I said, once you sit down with a mediator and they talk to you, and maybe they work their magic and you agree, and you can come to some type of agreement. Like, say I didn't pay my Capital One bill for 7 months, and they decided to sue me because I owe them $4,000, and so they filed this small claim suit. We go there, their attorney is there, and the attorney says, hey, you owe us $4,000. What can you do? Can you pay us, $75 a month? And of course I say, oh no, not $75. That's too much. And then he goes, okay, what about, $60? And I say, maybe I could do 50. And the mediator says, that's a pretty good, he does his little talking, and the attorney for the other side, they know what they're going to take, what the lowest they can take when they go in. So he goes, 50? Yeah, I can do 50. So quickly, an agreement is written up, very, very basic, that says, you're going to pay $50 a month. If you don't pay $50 a month, the other side has an opportunity to just basically come back to court, tell the judge, or file a paperwork with the court telling them you didn't pay, and the judge will issue an order that says you owe them for the full balance minus any payments. So they're going to get a judgment if you do that, if you don't make payments. So what happens if you can't reach an agreement? If you can't settle something, what happens is you get issued a court date by the clerk of courts, and the case is set for a trial, which is basically a hearing in front of the judge. So you'll be headed to trial. And if your case goes to trial, like I said, you're going to see the judge. Both of you will get a chance to present your side to the judge, and the judge is eventually going to determine, basically, I guess it's not correct to say who has proven their case better. I guess that's not very accurate, to be honest. It's did the plaintiff prove his case? And the defendant has the ability to knock whatever case he has down, or the plaintiff has down somewhat, by presenting evidence or to refute statements or claims. So the burden is always on the plaintiff, the person bringing the suit, to prove to the judge that they should win. And the defendant basically is always trying to prove that they shouldn't win, and provide reasons why. And like I said, if the judge then, if he believes the plaintiff has proven his case, the judge is going to enter a final judgment in their favor. And almost all of the time in small claims court, the judgments don't include monetary damages, because they're suing you for whoever the defendant's generally being sued for, a dollar value of damages. If the judge believes the defendant has successfully refuted, and the plaintiff hasn't proven their case, the judge is going to enter a final judgment in favor of the defendant, which means the defendant wins and the plaintiff gets nothing. Sometimes there could be multiple claims in one little small claims case, and maybe the judge says, hey, I think you proved claim A, but claim B, not so much. So there can be a judgment, that he says, plaintiff wins claim A and X amount of money is due, but plaintiff, the plaintiff failed to prove B, so that judgment is found against or in favor of defendant on claim B. So it's kind of a split, but there is that possibility. And during the trial, that's when you get the chance to present your side. You present relevant evidence and witnesses to help prove your statements or disprove the other person's case. If you're the defendant, try to disprove the plaintiff. You can bring witnesses. You're going to need documents that help back up your story. That's the time when it kind of, you'll have the Judge Judy moment where, you have paper, you have a contract or something, and you can show, or you have a witness that was there, and that's going to say, hey, I did not agree to this, or I did not, I didn't sign anything. I think it's a forgery. It could be anything, but that's how you go about that. It's your typical. Okay, so as I said before, typically small claims cases are done without a jury. There's a judge, and it's Judge Judy type, he sits up on the bench, and he is the one who hears the case, and he makes the decision based on the law himself. But can you have a jury trial in small claims? Yes, you can. But you can only get a jury trial if it's requested, and if it's requested properly. The only time the plaintiff can request a jury trial is at the time they file the case. So they have to request a jury trial basically when they file the case. And it's generally in writing in the statement of claim saying, I would like a jury trial. The defendant can request a jury trial within 5 days of being served with the the statement of the claim. So once you become aware of it, you have 5 days to request a jury trial, or you can request it at the pretrial conference, one of the two. If neither one of if no one requests a jury trial within these specific time deadlines, it's going to be deemed that you waive jury trial, and you're not going to get one. I'm going to say the rules are written this way. The rules are basically there for a reason. Small claims, they're trying to get these cases through the system. They're generally smaller in scope and less complex than other cases. And quite honestly, if you're asking for a jury trial during a small claims court, you're probably going to get a lot of resistance, and the judges aren't going to like it. Just because it's generally not done. And I can tell you that if you're the plaintiff and you're wanting a jury trial, you're going to be waiting. But nowadays, because of COVID-19, there's a major issue with bringing juries in and social distancing in order to have a jury trial. So you're likely not going to see a trial date for a long time if you want a jury. So after the trial, obviously, in theory, somebody wins and somebody loses. So you're the plaintiff and you won your case. Now you have a judgment. What do? Well, collecting a judgment is a lot harder than getting a judgment. I often tell people that a judgment is a piece of paper and it says somebody owes you money, but that's all it does, is it says they owe you money. It doesn't guarantee that you're going to ever get that money. It is there though, and it is proof that somebody is owed money. In order to get that money, many times you're going to have to continue with the court process, and you're going to have to go through more court hearings and stuff in order to try to collect. There are procedures set forth for the court to issue orders and things like that will assist you in getting that money, but it's going to ultimately be on you. The court's not a collection agency. And also, if you go there, it's probably going to cost you additional money because you're going to have to file more paperwork, and you're probably going to need an attorney for collections issue to try to collect the money, even if you get the judgment by yourself, because it's just very complex and it's very difficult. So I lost. Now what? There's a judgment against me. Well, you owe somebody money. There's a piece of paper that says that. There's a few things you can do. I mean, obviously, you could pay them the money if you have it. Judgments are recorded in the county records, and they're also going to hit your credit report. So there's going to be a record that you owe this person money, and if you don't take care of it, it's going to hit your credit report, and it's going to be a stain. Until it's listed on your credit report as paid, it's going to be there, and everyone's going to see it if you're looking for money or looking for a loan. You could also not pay the other side and make them go through the hoops of having to, go take further legal action to try to collect. They're going to try to collect, depending on who they are. They're going to spend various, amounts of time and effort to collect. If it's a debt buyer, like say I had a Capital One card and Capital One said, I'm not even going to try this. I'm going to sell it to, ABC Investments, who is going to try to collect it from, I know that they're a debt collector or debt buyer, and you get sued by ABC instead of, Capital One. Well, ABC, if they bought it, they're probably going to try to collect on it, because that's how they make money. So you can almost bet that they're going to try to do something. And, like I said, if you don't pay, you can't be surprised when the creditor of the judgment holder or if they've sold that to somebody else, you can't be surprised when they try to come after you. And the typical ways they do that are garnishment of your wages, which means that, under, certain circumstances, they can take up to 25% of your paycheck every week, um, until the debt's paid, or they could do both. They can also get a garnishment against any bank account that you may hold. And what'll happen is the bank will freeze all your money in the bank until till the issue's resolved in court, and the court tells them either don't take his money, or take his money and give it to the bank. So they can hold all of your money up to the amount of the judgment. So if you had $4,000 in the bank and you had a $4,000 judgment, the bank's going to freeze that $4,000. You're not going to get to use it. So your mortgage payment that you had coming out of that $4,000 isn't going to be made. Your car payment coming out automatically isn't going to be paid because there's no money in there. So these are things to worry about if you have a judgment against you and you know that the creditor, is going to come after you or actively seek to recover. Garnishment is kind of a nasty process because typically by the time it's coming, they've already frozen your bank, or they've contacted your boss and have the information about what you make and things like that. And they've already basically started the process of getting your wages withheld. They're not necessarily, your company may have to withhold the wages and then not give it to the bank or give it to your creditor right away. They hold it until the court tells them to give it. So, you're going to be back in court. You might be coming to legal aid and saying, help, I don't got any money and this is what's happening. And we can try, like I said, under certain circumstances, you can get that money released, or it can be considered exempt, but not everybody has that luxury. So, be careful. So the next thing is, I was basically kind of talking about what you do if you're a plaintiff and filing the case, and we mixed in some of the defendant stuff, but what is the process if you're just a defendant? Okay. Well, what do you do if you get served with a summons? The most important thing that you can do is not miss your pretrial conference. If you miss your pretrial conference, you are going to lose, and you are going to automatically get a judgment against you for the amount they're requesting, almost always. There are ways that say, something happened, you had a heart attack, or you got in a car wreck. You can ask the court to reset for those reasons, but can expect to need to prove it. So do not miss it if possible. Okay. Unlike a lot of other things, other lawsuits, when you're served with any other lawsuit, basically, you're given a time frame on the lawsuit to respond in writing to the court and to the attorney for the other side. Small claims, you are not required to file any type of written response to the lawsuit. You don't have to do anything until you show up at the pretrial conference. So that's an advantage of, that's one good thing about small claims is you're not required. The only deadline is go to the pretrial conference. In eviction, you have 5 business days basically to answer an eviction complaint. Civil complaints, you have 20 days, 20 days to file an answer. So, that's a good thing here. And, if you're the defendant, you want to try to resolve this in the way that's going to best work for you. If you can do it before the pretrial, if you can talk to the people before even the pretrial, that's good. Or if you're at the pretrial and you can solve it and work it out, it's always a good thing. If it's a matter of principle, sometimes it pays to have principles. Sometimes you will win, but sometimes having principle makes you pay, meaning that legally, your case could be not sound. It could be totally wrong morally or any, and that, but legally it is your case. The case against you is sound, and you're going to, you could lose, and could lose badly. So, I mean, sometimes, if you can work it out, I always say work it out. And if you don't reach any kind of agreement at a pretrial, the next thing you have to do is prepare yourself for trial. The court is gonna, you're gonna have to find, if you have witnesses, anybody that can provide, relevant testimony, something that actually is important to the case, not just because he's my friend Joe, he can say I'm a good guy. That's really not going to help you. If he happens to be there, if Joe happened to be there when the event happened that leads to your thing, well, then maybe he's somebody who you might want to ask if he can show up. If you have any documents, if you have any emails, text messages, things like that, you're going to want to try to produce those, reduce them down to paper. So do you need to, send them to copy and paste them, or take screenshots, or do something that's going to allow you to show the judge on paper, and you're going to be able to give to the judge so that he can put it into evidence as part of the trial, that that you need to do that stuff and get ready, because you're only going to get basically one shot at this, and that's your trial. So make it, you got to make it count. A lot of times you'll get an order from the court. Now, when they give you your trial date, there's going to be an order that says something like, 7 days before, 5 days before the court date, you must exchange names of witnesses or documents that you plan on using in court for evidence at your hearing. So you need to do those things. The consequence for sometimes not listening to those court orders is not having those things allowed to be presented to the court. So if a judge puts it in writing and says, do this, do this, do this, even if it's on a pre-printed form, do it, because you don't want to lose you don't want to lose not your evidence, because the judge won't let it in because you didn't follow the order. You didn't exchange it as he told you to. You didn't divulge who you were going to call, that kind of thing. So pay attention to the orders, read them. It's very important that you do these things. And, if you don't think that you can do this by yourself, you always have the option to hire an attorney or find an attorney, talk to them. Small claims court is like the light version of court. It's like the less calories, but it's still got all the same great taste. It's still court, and things that happen there still have consequences. So if you don't think you can take it, if you don't think you can handle it, and you don't think you can go and do this, or you need advice, it might pay to, maybe you don't need to hire an attorney, but maybe you need to talk to one and see, hey, is this a good defense or something? Talk to them. Try, apply, if you don't have the money for an attorney, apply for legal aid, or, make a consultation appointment through the lawyer referral service at the Bar Association in Naples, in Collier County. They will provide you with an attorney that for $50, they'll give you a half-hour consultation, and you can kind of pick their brain about things. You just have to be quick about it. So that, that's always an option. But don't take oh, it's just small claims. I mean, I don't know. I don't want to give somebody, $8,000 if I don't need to or shouldn't. So you got to take it, you got to take it seriously. Just because it says small claims don't buy into it. So COVID has had a very hard and harsh effect on the court system. The reason being is courts, everything was done in person. Like I said, we used to all, on small claims court day, you'd go in and there'd be 50 people that have cases there, um, sitting in the courtroom waiting to have their pretrial conference. And that's a lot of people. I mean, it takes a while because you go through with a mediator. And so you could be there, it used to be 8 o'clock in the morning, or eight, I think it was 8 was the first one, and then like 10. I mean, I've been there for hours and hours and hours, waiting and trying to, to try to work something out and just maybe even to get heard. So, there was a room full of people, and that doesn't happen anymore. There is no more room full of people at the courthouse, or at least there shouldn't be. And they've been working to keep that, in pretty much down. So, things when initial COVID things came out, the courts basically had to shut down. They had to shut down, like I said, anything in person. So that all just ground to a halt. And at first, people didn't stop filing court cases, and there was a bunch of stuff waiting to be heard. There was already stuff in the system. So when we stopped, because small claims court is not, it's not a life or death type of thing. And in the court system, they have what they consider essential and non-essential hearings. Essential hearings are basically things that, are going to protect life, liberty, prevent substantial harm, that kind of thing. Small claims generally doesn't fall into the essential hearings category. So it took the court system a little bit to get ready and to figure out what we're going to do. And what the courts ended up doing, as you probably know, is they went remotely. They went on the computer or telephone. Generally now it's via Zoom, which is a private company. But like I said, almost everything had to stop, and we're trying to catch up now that we have Zoom. Once we decided that that's how we were going to move forward, and that was probably going to be the best practice for everybody, we started picking back up, and now we're just playing catch up, I guess, as the system is. It's taking a while. They're working through it, and things such as, at first they were only holding like certain types of things, certain types of hearings via Zoom, minor matters. And now that we've got the system in place and everything is going better, they're starting to hold trials and all kinds of, other hearings via Zoom. So, things are back almost to full swing, but just remotely. And like I said, Collier County in the 20th Judicial Circuit, which is, the area we live in, we're using Zoom to hold hearings and meetings and all that, or any kind of thing. Zoom is a product, that can be used on just about any modern smartphone, tablet, iPad, computer, any of those things. It does not require you to download an app. It does not require you to set up an account. It just requires you to input some information that if you do have a Zoom hearing, the clerk of courts provides you with that information. And instead of going to the courthouse at 8 o'clock in the morning, you go to your computer or your phone and you log on and you wait there to be, you wait for your case to be called. And once you're called, they break you out into a room by yourselves and you do your business. Very similar. You're just not in the same room, to be honest. And the Zoom doesn't cost you anything. If you're participating in it, the court has actually paid, I guess, a subscriber fee or whatever, things of that nature. if you want to use Zoom privately, you might need a subscription, but not for right now, not for court purposes. You don't have to have anything. The only problem is sometimes you run into some people who don't have the technological ability to participate. Sometimes maybe they are going to come in by phone. It just depends. But if you're one of those people and you have a problem, you need to immediately alert the court that you have an issue, because unless you tell them, they're going to assume you can do it and you're going to be there. And if you don't want to lose out because you didn't have this ability. I've had a few people already that I've had to try to help because they weren't technologically proficient. They didn't have a computer, a smartphone, anything, and they maybe spoke a foreign language that was hard to communicate. Maybe it wasn't one of the common foreign languages. They've had to try to communicate, and it just didn't work right. And so we've had try to help people get the hearing reset so that they can participate in another manner. But that's COVID is taking a toll on the system a little bit, and the system's fighting back. It's really running a lot more smoothly than it has in the past, and I have to say that it's fairly runs fairly well. To be honest, I could honestly see some of the smaller things in court, some of the smaller cases and things like that continuing to be held by Zoom or remotely even after COVID. There's something to be said for not having to go to the courthouse and waste a bunch of time driving there and driving back and waiting. If you're on Zoom or if you're online, you can just basically go straight in, and you don't spend a lot of time doing other stuff. So basically that's my overview of the small claims court system. If you're sued and you need help, you're always welcome to see if you qualify for legal aid assistance. We do. I happen to be one of the people who does the small, the most of the small claims or suits like that. We do provide assistance, and or if you know another attorney, you can, or you want to seek private legal counsel, that's fine too. I just want to say thank you all for viewing this today. Listed here are a few of our partner agencies that help support legal aid, particularly my unit, which is the Consumer Law Unit, the Community Foundation of Collier County, Collier County Comes Together Fund, United Way of Collier County and the Keys, big supporters. And the government also does kick in. The U.S. Department of Treasury, the Florida Department of Emergency Management, and the Collier County Community and Human Services Division all provide some measure of assistance to us. So with that, I have nothing further. So I wish you a good day and good luck. If you need help, we're here for you. Thank you.